Mr. Ehrhardt, theft by power of penalty. You treated Barbara Driscoll's accounts as your own while she had dementia.
We have a choice to look after her.
You raised her credit limit.
John Ehrhardt operated without meaningful oversight for years as the continuing power of attorney for Barbara Driscoll, a woman with dementia who depended on him completely. Not one person checked what he was doing with her money until she was already gone.
To $15,000 and spent it on yourself. The judge called her.
Lawyers say automating more about Barbara's finances.
He would not get the chance to explain it away. 12 years before this confrontation, in a quiet Kingston area law office, Barbara Driscoll had signed a single document granting John Ehrhardt continuing power of attorney over everything she owned. 1 month later, she was formally diagnosed with dementia. What happened between that signature and her death in long-term care would eventually be reconstructed by Ontario Provincial Police investigators, forensic accountants, and a jury impaneled in Frontenac County. The number they arrived at was more than $82,500. The sentencing judge would describe what Ehrhardt had done with Barbara Driscoll's assets in 5 words. He called her his personal automated teller machine. Before we go any further, I have to ask, would you trust your partner with full legal authority over every dollar you own if a doctor told you tomorrow that your memory was starting to fail? Drop your honest answer in the comments below. And if this is your first time on the channel, hit subscribe now. We cover the cases that ordinary headlines bury every single week, and the next one is already in the works. John Ehrhardt was born in the autumn of 1943 in a small farming community south of Sharbot Lake, in the eastern Ontario rural belt between Kingston and Perth. His father was a tractor mechanic who ran a small repair operation out of a converted dairy barn at the edge of a county road. His mother kept the books for the business and raised 4 children in a 2-story clapboard house with a wood stove in the kitchen and a wringer washer on the back porch. Money was tight but predictable. The Ehrhardts ate what came out of the garden, drove vehicles his father kept running long past their useful lives, and went to the same small Anglican church every Sunday for 40 years. By the time John finished grade 12 at Sharbot Lake District High School in the early 1960s, he had already worked summers at his father's shop, at a feed mill in Hartington, and on a road crew laying gravel between Verona and Westport. He never went to university. There was no money for it, and the idea of leaving the region did not occur to him in any serious way. He took a job at a small machine shop in Kingston that did contract work for the Canadian Forces Base, fabricating brackets, fittings, and replacement parts for military vehicles. The work was steady. The hours were long. The pay was unremarkable, but it was reliable, and he stayed at the shop for the better part of 3 decades. He married for the first time in 1967, in the same parish hall where, decades later, he would meet the woman whose money he would eventually steal. The first marriage produced 2 children, a son and a daughter, and lasted 23 years before ending in a quiet separation in 1990. He kept the truck. She kept the house. The children, by then teenagers, kept their distance from both parents for several years afterward. For most of the 90s and the early 2000s, John lived alone in a rented bungalow on the outskirts of Kingston. He worked at the machine shop until the owner retired and sold the equipment for scrap in 2004. After that, he picked up small contract jobs, welding for a local fabricator, fixing snowblowers and lawn mowers for older neighbors, running errands for people who could no longer drive themselves. His old age security check and his Canada pension plan payment arrived on the same Wednesday every month. He did not have significant savings. He did not have a will. He did not have, in the language of estate planners, anything you would describe as a substantial financial position. He met Barbara Driscoll in the spring of 2007 at a community fundraiser held in the parish hall of a small church near Inverary. Barbara was 64. She had been widowed for 9 years. Her late husband had left her a comfortable, mortgage-free home in the countryside outside Kingston, a modest portfolio of investments built up over 4 decades of his work as a regional sales manager for an agricultural equipment company, and a paid-off car in the garage. She volunteered for the local food bank, sang in a small women's choir, and traveled with a group of friends to Niagara-on-the-Lake every September for the theater festival. People who knew Barbara in those years described her in consistent terms. She was generous. She was slightly shy. She was careful with money in the way of someone who had lived through her own parents' Depression-era stories and never quite shaken the lessons. She was warm with everyone she met. She was also, in the words of one neighbor later interviewed by Ontario Provincial Police investigators, the kind of person who never wanted to make a fuss. She handled her own bills. She drove her own car. She managed her late husband's investment accounts through the same advisor he had used since the late 1970s, and she called that advisor on the first Monday of every month for an update. John and Barbara began seeing each other within weeks of the fundraiser. Within a year, he was spending most of his evenings at her home. Within 2 years, he had moved in entirely. The rented bungalow on the outskirts of Kingston was given up. The relationship was never formalized through marriage. Under Ontario law, after 3 years of cohabitation, the two of them qualified as common law partners for the purposes of family law claims, dependent relief, and in time, the formal documents Barbara would eventually sign, giving him control of her affairs. By 2010, they were introducing each other that way to neighbors, to her extended family, and to the staff at the bank branch where Barbara kept her checking and savings accounts. For the first several years of the relationship, by every external measure that anyone could see, John Ehrhardt appeared to have stepped into the role of a devoted late-life partner. He drove Barbara to her medical appointments. He shoveled the long gravel driveway in winter. He cleared the eavesdrows in autumn. He did the small repairs around the house that her first husband had once handled. To Barbara's friends, who had quietly worried about her living alone after the widowing, he looked like a stabilizing presence. To Barbara's children, who lived in other provinces and saw their mother only at Christmas and the occasional summer visit, he looked like proof that she was not lonely. To the staff at the bank, he looked like a husband in everything but the legal paperwork. None of those external observers had any reason, in the early years, to look at what was happening inside Barbara's accounts. To understand what happened next, you have to understand how a continuing power of attorney works under Ontario law. The Substitute Decisions Act, 1992, is the statute that governs how Ontarians delegate decision-making authority over their property and their personal care to someone else. The most powerful instrument the Act creates is what is formally called a continuing power of attorney for property. The word continuing is the key. A continuing power of attorney remains valid even after the person who granted it loses the mental capacity to manage their own affairs. That is the entire point. It is designed deliberately to function in the exact moment when the person who signed it can no longer protect themselves. The person who grants the power is called the grantor. The person who receives it is called the attorney. The word attorney in this context does not mean a lawyer. It means anyone, of any background or profession, whom the grantor names in the document. It can be a son, a daughter, a neighbor, a common law partner met 5 years earlier at a parish fundraiser. There is no licensing requirement. There is no professional college overseeing the conduct of attorneys for property in Ontario. There is no continuing education requirement. There is no annual financial filing with any government office. Once the document is signed and witnessed, the attorney holds full operational authority over the grantor's financial life, and that authority continues until the grantor dies, formally revokes the document while still mentally capable of doing so, or a court intervenes. What the attorney is legally required to do is act as a fiduciary. That word carries enormous weight in Canadian law. A fiduciary owes the highest duty of loyalty and care that one person can owe another in our legal tradition. The attorney is required to act exclusively in the grantor's best interests. The attorney is required to keep the grantor's property strictly separate from the attorney's own property. The attorney is required to keep careful, contemporaneous records of every transaction. The attorney is required to spend the grantor's money on the grantor's care, the grantor's housing, the grantor's medical needs, and the grantor's reasonable comforts, and on absolutely nothing else. The Ontario system rests on trust, and that trust is institutional in nature. The bank teller who processes a transaction for an attorney does not investigate whether the transaction is for the grantor's benefit. The investment advisor who follows the attorney's instructions does not audit whether those instructions reflect the grantor's interests. The credit card company that processes a credit limit increase request from an attorney does not call the grantor to confirm she still wants more credit available on her account. The Office of the Public Guardian and Trustee, the provincial body that has oversight authority over attorneys for property, does not actively monitor most powers of attorney. It only investigates when a complaint is filed, when a family member raises an alarm, when a financial institution flags something unusual, or when the conduct comes to its attention through some other external route. For an attorney who is determined to abuse the role, that institutional gap is not a flaw. It is an opportunity. The system was built on the assumption that the person the grantor trusted enough to name would honor the trust. The system was built on the assumption that the love or affection or kinship that motivated the grantor to choose this particular attorney would carry forward into the attorney's conduct. The system was built, in other words, on the assumption that intimate relationships do not produce predators. And in 2014, when Barbara Driscoll's family doctor told her gently that her memory had begun to slip, the question of who would hold that opportunity over her financial life was decided in a single quiet afternoon. The early summer of 2014 was the institutional turning point. Barbara was 71 years old. She had been forgetting names she had known her whole life. She had been losing track of which monthly bills she had already paid. She had driven to a familiar grocery store one Tuesday afternoon and could not remember, on the drive home, which back road would take her to her own house. She had eventually pulled into a gas station, sat in the car for 20 minutes, and called John to come and get her. Her family doctor referred her, the following week, for a cognitive assessment at a Kingston clinic. The assessment returned what was, in the careful clinical language used in Ontario practice, a finding of declining mental capacity. It was not yet a formal diagnosis. It was a measurement. It documented that Barbara's executive function, her short-term memory, and her ability to manage complex sequential tasks had all dropped below the range considered typical for a woman her age. The clinical recommendation was a follow-up specialist appointment at a memory clinic, supportive intervention from family, and, if she had not already done so, the execution of legal documents to designate someone she trusted to make decisions on her behalf as her condition progressed. She had no surviving spouse. Her children from her first marriage lived in other provinces and had limited involvement in her day-to-day life. The person who drove her home from that assessment appointment, who made her dinner that evening, and who was already sleeping in her bed by that point in their relationship, was John Ehrhardt. Within weeks, Barbara was sitting in a Kingston area law office, signing a continuing power of attorney for property. John was named as her sole attorney. There was no co-attorney appointed. There was no requirement in the document for John to provide a periodic accounting to any third party. There was no annual review condition. The document was straightforward, standard in its form, and, in legal terms, completely valid. 1 month later, the specialist appointment that the cognitive assessment had recommended took place at a Kingston memory clinic. The clinician's diagnosis was Alzheimer's-type dementia. The clinical notes referenced the recent power of attorney execution and recorded, in standard institutional language, that the grantor was now substantially reliant on her attorney for the management of her financial affairs. The first irregularities, the ones that forensic accountants would later trace through Barbara's bank statements, began appearing in the months after the power of attorney was executed. They did not appear all at once. They appeared the way these things always appear in the documentary record, a withdrawal that was slightly too large to match Barbara's lifelong spending patterns, a cash advance that did not align with any documented expense for her care, a purchase at a retailer Barbara had never patronized in her life, a small transfer to an account that was not hers. None of those early transactions, taken on their own, would have triggered an alarm at the bank. None of them, taken on their own, would have prompted a call to a family member. They were too small. They were too ordinary. The man processing them was the legally designated attorney for property of the woman whose money was being moved. The transactions had the formal architecture of legitimacy. The escalation took place gradually, in the way that these schemes almost always escalate. The withdrawals became larger. The frequency increased from monthly to weekly, to, at certain points, several times in a single week. The categories of expenditure broadened to include items that had no plausible connection to Barbara's care. Restaurant meals at establishments Barbara was not physically capable of visiting, tools, equipment, fuel for vehicles she did not drive and had never driven, gifts for individuals she did not know. And then, at some point in this period, John Ehrhardt did something that the forensic reconstruction would later identify as the operational pivot of the entire scheme. He used his power of attorney authority not just to access the resources Barbara already had, but to actively expand the resources available to him. He went to the bank. He presented his authority as attorney for property. He requested that the credit limit on one of Barbara's accounts be increased. The bank, presented with a valid power of attorney document and a request from a man holding apparent fiduciary authority, processed the increase. The new credit limit on that account was $15,000. It was not enough simply to access the resources Barbara had accumulated over a lifetime of careful, patient saving with her first husband. He had to widen the channel. He had to make more money available to flow through. By the time Barbara entered long-term care, the operational architecture of the scheme was fully in place. The bank accounts were accessible. The credit had been expanded. The investment accounts that Barbara's first husband had so patiently built over 4 decades were within John Ehrhardt's reach. The grantor, whose money was funding all of this, could no longer review her own statements, could no longer recognize most of the names that appeared on the transaction line items, and could no longer have understood what was happening to her, even if someone had carefully walked her through every page, every line, and every entry. The personal automated teller machine, in the sentencing judge's later language, had been built. Barbara Driscoll spent her final years in a long-term care residence in the Kingston area. The exact date of her admission is not part of the public record. What the public record establishes is the institutional reality of that placement. From the moment Barbara walked through the doors of the long-term care residence, her operational connection to her own financial life was effectively severed. Her bank statements were no longer arriving at her own kitchen counter, where she had once opened them on the first Saturday of every month with a sharp letter opener and a fresh cup of coffee. They were being delivered to the home John Ehrhardt now considered his own. Her credit card bills were not being opened by her own hands. Her phone calls to her investment advisor, the ones she had made monthly for 40 years while her first husband was alive and the 18 years afterward, had stopped completely. The few visitors who came to see her at the long-term care residence were old friends and family members. None of them brought up the bank balances. None of them had any reason to. What Barbara had in her room at the long-term care residence was a single chest of drawers, a small upholstered armchair, photographs of her late first husband, photographs of her children and grandchildren arranged on the nightstand, and a window that looked out onto a parking lot. What she did not have was the cognitive capacity, the documentation, the access, or the operational awareness to detect that a man she had trusted enough to name as her continuing power of attorney was treating her life savings as his own personal line of credit. There is a structural pattern in power of attorney abuse cases that investigators and prosecutors who work in this area know by heart. The grantor enters long-term care. The attorney's operational opportunities for diversion expand at exactly the same moment the grantor's operational capacity to detect the diversion collapses. The two curves cross. Everything that happens between that crossing point and the grantor's death takes place inside what investigators sometimes call the institutional dark zone. The conduct is happening. The transactions are being recorded. The paper trail is being generated slowly and patiently by the banks and the credit card companies and the investment firms. But no one on the outside is in a position to see it. No one on the inside is in a position to stop it. The grantor's accounts are simply ticking down, withdrawal by withdrawal, transaction by transaction. During this exact period, John Ehrhardt began a new relationship. He met a woman in the area. The relationship developed quietly, then less quietly. By the latter part of Barbara's institutionalization, John and his new partner were appearing together socially in the Sharbot Lake area. Barbara, in her long-term care room, did not know. Barbara's friends, who had quietly stopped visiting the home she had once owned because John now lived there alone, or with his new partner, did know, but had no standing to intervene in what they understood to be a private matter between common-law partners. On December 3, 2017, Barbara Driscoll died at the long-term care residence. She was 74 years old. The cause of death was complications of advanced dementia. The funeral arrangements were modest. The death certificate was filed. The estate was opened. And someone, somewhere, in the days or weeks after that funeral, opened a bank statement, ran a finger down a column of transactions, and stopped. We are about to get into the investigation, the trial, and the sentencing. Before we do, if this case is making you angry, put that anger in the comments. If you have ever helped manage a parent's, a partner's, or a grandparent's finances during a memory-related illness, tell me below what safeguards you wish you had known about beforehand. Subscribe if you want to see more cases like this one. These stories do not get the coverage they deserve, and that is exactly why this channel exists. The investigation that ultimately resulted in John Ehrhardt being charged by the Ontario Provincial Police in July of 2022 did not happen quickly. It took approximately 4.5 years from the time of Barbara Driscoll's death for the charges to be laid. That timeline is typical, and it is typical for a reason that anyone who works in financial crimes prosecution will tell you without hesitation. Power of attorney abuse cases are not built like robberies or assaults. There is no smoking gun in a single moment. There is no security camera that captured a single decisive act. There is no eyewitness who can testify to what happened on a specific day at a specific time. What investigators have, in cases like Barbara Driscoll's, is a paper trail measured in years. Bank statements, credit card statements, investment account records, care facility invoices, funeral home bills, property tax records, insurance documents, real estate transfer documents, every transaction on every account, from the date the power of attorney was granted until the date the grantor finally died. The forensic reconstruction in the Ehrhardt case began with a single observation. Someone, almost certainly during the routine administration of Barbara's estate in the weeks after her death, noticed a pattern in the bank statements that did not match the financial profile of a woman in her 70s who had been living first quietly at home with a common-law partner and then in long-term care. The pattern was not subtle. Once it became visible, it kept becoming more visible. The expenditures did not match Barbara's documented needs. The recipients of the transfers did not match Barbara's documented relationships. The credit limit on one of her accounts had been actively expanded to a number that bore no relationship to the way Barbara had ever used credit in her adult life. The matter was referred to the Ontario Provincial Police. Officers from the financial crimes side of the OPP took the file. The institutional name for this category of investigation is forensic accounting-based prosecution. The case files become enormous. The bank produces records. The investment firms produce records. The credit card companies produce records. The forensic accountant retained by the investigation works through the documents line by line, transaction by transaction, comparing each entry against a baseline reconstruction of what Barbara's legitimate fiduciary expenses ought to have been during the period covered by the power of attorney. What the forensic reconstruction revealed was straightforward in its arithmetic, even if it had been laborious in its assembly. The legitimate fiduciary expenses on Barbara's behalf during the period of the power of attorney were calculable. Long-term care fees, medical co-payments not covered by the Ontario Health Insurance Plan, personal care items, clothing, modest entertainment, hairdressing at the residence, family travel for occasional visits. the aggregate of those legitimate expenses, totaled across the years, was a number. The aggregate of the actual outflows from Barbara's accounts during the same period was a much larger number. The difference between those two numbers, what investigators in this area call the diversion figure, was more than $82,500. That figure is what eventually appeared in the restitution order at sentencing. It is not a guess. It is not a rounded estimate. It is the documented arithmetic difference between what Barbara's accounts should have paid out under a faithful exercise of the power of attorney and what they actually paid out under John Ehrhardt's exercise of it. The investigation also documented something else. The conduct had continued, uninterrupted, after Barbara entered long-term care. The investigation documented that the credit limit on one of Barbara's accounts had been increased to $15,000 at John Ehrhardt's specific request, made under his power of attorney authority. The investigation documented spending patterns that had no plausible connection to Barbara's care, her preferences, or her instructions. The investigation documented that, after Barbara's death, John Ehrhardt continued to live in the Sharbot Lake home he had previously shared with her, and the investigation documented that he was now sharing that home with a current partner he had met during the same period that Barbara was institutionalized in long-term care and unable to monitor her own financial affairs. By July of 2022, the OPP had enough. Charges were laid under the Criminal Code of Canada. The first count was theft by a person holding power of attorney, contrary to Section 331. The second count was theft over $5,000, contrary to Section 334, paragraph A. Both counts carried potential prison sentences. Both counts named John Ehrhardt as the accused. Both counts named Barbara Driscoll as the victim. Barbara had been dead for 4 years and 7 months when those charges were laid in her name. The institutional confrontation, when it came, did not arrive with a dramatic raid on the Sharbot Lake home. There were no flashing lights in the gravel driveway at dawn. There was no team of officers with a battering ram and a search warrant. The Ontario Provincial Police investigators who had built the file over the months preceding the July 2022 charges had what they needed in documents. They knew where John Ehrhardt lived. They knew he was elderly. They knew he was not a flight risk. The arrest took the form a financial crimes arrest typically takes in rural Ontario. Officers attended the Sharbot Lake address. They identified themselves at the door. They informed John Ehrhardt that he was being arrested in connection with criminal charges arising out of his exercise of the continuing power of attorney granted to him by the late Barbara Driscoll. They cautioned him in the standard form required under the Canadian Charter of Rights and Freedoms. They advised him of his right to retain and instruct counsel without delay. They advised him of his right to remain silent. What John Ehrhardt said in the immediate aftermath of being told that he was being charged with theft from Barbara, the woman who had trusted him to manage her finances for the final years of her life, is not part of the public record in the way that direct quotations from body cam footage in other jurisdictions sometimes are. What is on the public record is that he did not confess. He did not admit to the conduct. He did not acknowledge that he had used Barbara's accounts for purposes other than her care. He retained counsel. He exercised his right to remain silent. He was released on a promise to appear, with conditions consistent with the standard pretrial release framework for nonviolent property offenses in Ontario. The position the defense would take at trial began to take shape in the months that followed. It would not be a position of denial that the transactions had taken place. The bank records made that impossible. It would not be a position that the power of attorney did not exist. The signed document made that impossible. It would be a position about characterization. The transactions, the defense would argue at trial, were not theft. They were the ordinary commingling of finances between two people who had lived together as common law partners for a decade. They were Barbara's contribution, freely and lovingly given, to a shared household. They were reasonable expenses incurred for purposes Barbara, had she been asked while still mentally capable, would have endorsed without hesitation. The Crown would argue something fundamentally different. The Crown would argue that what John Ehrhardt had done was a betrayal of the highest fiduciary duty Canadian law recognizes between two people who are not married to one another. The Crown would argue that the diagnosis of dementia, 1 month after the power of attorney was granted, transformed every subsequent transaction into a question of fiduciary loyalty. The Crown would argue that Barbara, in the final years of her life, had been used as a personal automated teller machine by the man she had trusted most in the world. The jury would decide which of those two narratives the documentary record supported. The trial began in June of 2025 at the Frontenac County Courthouse on Court Street in Kingston, Ontario. The judge assigned to the case was Ontario Superior Court Justice Graeme Mew. The jury was impaneled. The Crown opened its case with the documentary record. The Crown's evidence consisted, essentially, of paper. The 2014 continuing power of attorney. The clinical records establishing the assessment of declining mental capacity that had preceded its execution by weeks, and the formal dementia diagnosis that had followed it by a month. The bank statements, in their entirety, from the date of the power of attorney grant through the date of Barbara's death. The credit card statements, the investment account records, the records of the credit limit increase to $15,000, the forensic accountant's reconstruction of the legitimate fiduciary expenses, and the documented difference of more than $82,500 between those expenses and the actual outflows. The Crown called witnesses to authenticate the documents. It called the forensic accountant to walk the jury through the reconstruction one column at a time. It called witnesses to establish Barbara's daily life during the period of the power of attorney, what her actual needs and expenses had been, and what role John Ehrhardt had played in managing her affairs during that period. The defense cross-examined. The defense put its theory of the case to the jury. The transactions had occurred, yes. The power of attorney existed, yes. But this had been a shared life. This had been a household with commingled finances. This had been the ordinary, messy, undocumented financial reality of an older couple living together. To call it theft, the defense argued, was to misunderstand the nature of the relationship that had existed between John and Barbara in the years before the dementia, and to impose a clinical legal standard on a private human bond that had never been governed by spreadsheets. The jury deliberated. The jury returned its verdict. On both counts, theft by a person holding power of attorney under Section 331 of the Criminal Code, and theft over $5,000 under Section 334, Paragraph A, the verdict was the same: guilty. The sentencing hearing was held on November 14, 2025. Sentence was imposed on December 5, 2025. Justice Mew released written reasons under the citation R versus Ehrhardt, 2025, ONSC 6850. The written decision contained the language that has since become the institutional shorthand for the case. Justice Mew found that John Ehrhardt had committed crimes of dishonesty involving a breach of trust. Justice Mew wrote that he had no doubt the jury had concluded, as he himself had concluded, that John Ehrhardt had assumed full control of all of Barbara Driscoll's assets and had treated them as if they were his own. And Justice Mew wrote, in the line that the legal community in Ontario has since circulated through the elder law and estates bar, that John Ehrhardt had effectively used Barbara Driscoll as his personal automated teller machine. The sentence Justice Mew imposed was 2 concurrent 1-year prison terms. 1 year on the Section 331 count. 1 year on the Section 334 count. Concurrent, meaning the 2 terms would be served at the same time rather than consecutively. Justice Mew also imposed a restitution order requiring John Ehrhardt to repay more than $82,500 to the estate of Barbara Driscoll. The institutional significance of the sentence, beyond what it meant for John Ehrhardt personally, is what estate litigation practitioners noticed in the days after the decision was released. Power of attorney abuse cases in Ontario are overwhelmingly resolved through civil litigation. The estate sues the attorney. The court orders the attorney to repay. Criminal convictions in this category of case are, in the words of one Toronto estate litigator, commenting on the Ehrhardt decision in the days afterward, very rare. The decision, she said, demonstrates the high bar that fiduciaries and attorneys are held to in Canadian law, and the great risk and liability that they face if they misappropriate funds. The Ehrhardt decision is currently under appeal. The Ontario Court of Appeal will, in due course, review the conviction and the sentence. What the trial court decision has already established is a public, written, judicially reasoned account of how a continuing power of attorney granted at the threshold of cognitive decline became, in the hands of the common law partner who held it, the institutional architecture for the slow, deliberate, multi-year diversion of more than $82,500 from a woman who could no longer count it, no longer track it, and no longer ask where it had gone. John Ehrhardt was 82 years old when Justice Mew sentenced him. He had outlived Barbara Driscoll by 8 years. He had spent those 8 years in the home she had once owned outright, with a partner he had met while Barbara was still alive and institutionalized in long-term care. The 2 concurrent 1-year prison terms will, if upheld on appeal, be the first time in his life that he will spend a night in a correctional institution. Barbara Driscoll trusted him with the document she signed at a desk in a Kingston area law office in the early summer of 2014. A jury in Frontenac County decided, 11 years later, exactly what that trust had been worth to him. This case was quiet. The next case on your screen right now is louder, uglier, and somehow even harder to believe.